These are appeals in the matters of Branco-Bonfim and Secretary of State for the Home Department and the King on the application of Branco-Bonfim and the Secretary of State for the Home Department.
Please, Your Lordship, I appear for the appellant, Mr. Branco-Bonfim, and my learned friend, Miss Howes, appears for the respondent Secretary of State.
May I begin by asking how I should correctly pronounce your name?
Cuba.
Cuba.
Yeah.
Thank you.
Thank you. My Lord, you will have seen from the papers that there are two parts to this case. There's the appellant's appeal against the denial of relief, and there's the cross appeal by the respondent in relation to the decision that Upper Tribunal Judge Perkins made in favour of the appellant regarding the substantive legal issue as regards rights of appeal.
Yes. Now, can I just see if I've understood what the position is? The Upper Tribunal decided that your client had an in-country right of appeal.
Yes.
But he declined to grant relief on the basis that the outcome wouldn't have been different if the Secretary of State had done the right thing, putting it briefly. But having decided that you've got a in-country right of appeal, why don't you exercise it? In other words, why does it matter that you didn't get relief in the JR? It's been decided your client's got this right of appeal.
Well, my Lord, it may be said against us that what we haven't got is a quashing order against that decision.
Well, the decision, this is another thing I don't quite understand, the decision was a decision to refuse your client's human rights claim.
Yes.
That was the decision. And you're not seeking to quash that decision. You want to appeal against it, but you're not seeking to quash it. The decision did include the statement that your client did not have an in-country right of appeal, which you dispute. Why didn't you just issue a notice of appeal in the FTT and let the FTT decide whether it had jurisdiction or not?
Well, my Lord, I think our concern was that because of the effect of the denial of relief, the FTT would not entertain that appeal because of the use by the court, as in the Upper Tribunal, Section 31(2)(a).
Right, okay.
My Lord, that's...
Anyway, that's the position.
Yeah, no, that's how we understood the impact of this to be. My Lord, in terms of the presentation of the appeal, I've had a discussion with my learned friend. I don't know whether you want to proceed with my appeal first or hear the cross appeal in relation to the decision that was in our favour.
Well, I think it probably makes sense to hear the cross appeal first, because if the Secretary of State was correct, then your appeal doesn't rise. If, on the other hand, she was incorrect, then it does.
Yeah.
Mr. Lords, may I address the point that your Lordship has raised about why not just appeal to the First Tier Tribunal and make them make a decision about jurisdiction? I must confess the same thought had occurred to me, but the Secretary of State at the beginning of this claim did not plead that the claimant had an alternative remedy, namely, why don't you just test the water with the tribunal? That is because of the original grounds 2 and 3, which were a challenge to the lawfulness of the 2016 regulations and the provisions restricting the appellant to an out-of-country right of appeal. As we now know, permission was only granted on ground 1 to proceed, and by that point, it was a bit late in the day to plead adequate alternative remedy because permission had already been granted. The position now is, so far as the Secretary of State is concerned, is that there is a decision of the Upper Tribunal that the Secretary of State says is wrong. So far as the Secretary of State is concerned, the purpose of this appeal is to correct that unlawful decision. Yeah. That's my thinking, my Lords, in relation to why we are where we are now. Would it assist your Lordships if I gave an overview of the facts?
Yes, by all means. Well, we have read them, of course, in the Upper Tribunal decision and indeed in your skeleton argument, but if you think it would help to go over that again, please do.
If your lordships are on top of the facts, then I won't take up the time by going through them. I simply would have taken your lordships to the judgment of Mrs. Justice Heather Williams, which contains more detail in relation to the facts and deals with some of the detail of the correspondence, paragraphs 11 to 23.
Yes.
Then may I move, my lords, to introducing the legislation, the Immigration European Economic Area Regulations 2016, now of course repealed, but with saving provisions. May I begin by asking your lordships to look at the definitions contained in Regulation 2, which is in the Authorities bundle at page 50. On that page, your lordships will see the definition of an EEA decision. It means a decision under these regulations that concerns, and then a number of decisions are listed. This appeal is concerned with C, a person's removal from the United Kingdom. Next, may I ask your lordships to turn to Regulation 23, which deals with exclusion and removal, at page 80. Regulation 23.2 says, a person is not entitled to be admitted to the United Kingdom by virtue of Regulation 11 if that person is subject to a deportation or exclusion order, except if the person is temporarily admitted pursuant to Regulation 41, not relevant for our purposes.
The original removal was under Regulation 23.6, I think.
Well, yes, 23.6b.
As applied by Regulation 27.
Lord, yes. And we'll see here that 26, subject to paragraphs 7 and 8, an EEA national who has entered the United Kingdom may be removed if B, the Secretary of State has decided that the person's removal is justified on public policy grounds, Regulation 27. And then 8, a decision under paragraph 6b must state that upon execution of any deportation order arising from that decision, the person against whom the order was made is prohibited from entering the United Kingdom. So the position is that the appellant was deported in November 2018, and he is not entitled to be admitted to the United Kingdom.
Do we, forgive my ignorance, but do we know as a matter of fact that Regulation 23, paragraph 8 was complied with? I know it says what must be done, but one knows that what regulations say must be done isn't always done.
My lord, we have the deportation notice in the core bundle. May I just have a moment to turn it
Sure.
I think it's 20th of November 8, 2018.
My lord, yes. So the decision is at page 319.
Thank you.
That is paragraph 59 of the decision, page 325. So the appellant was informed he has no right to stay or be admitted.
Well, it says he has no lawful basis to remain in the United Kingdom, should leave as soon as possible. Don't leave, you'll be here illegally. But does it say that they're prohibited from entering the United Kingdom?
It says at paragraph 47 that you must apply for permission in advance of attempting to re-enter the United Kingdom. And at paragraph 41, sorry to work backwards through the decision, he's told he must apply to re-enter the United Kingdom.
But that's about a period.
It's already 47, 48 and 49.
Lord, yes, those paragraphs are also. The overall effect in my submission of these paragraphs is that the appellant is told that he can't come to the United Kingdom unless he applies for permission to be readmitted, and that he must leave immediately.
Totally convinced at the moment this is entirely in accordance with paragraph 8. Because what paragraph 8 requires is a statement that the person against whom the order is made is prohibited from entering the United Kingdom until the order is revoked or the period specified in the order. And it's that point about revocation of the deportation order that seems to me to be of some importance. But anyway, thank you for your assistance.
My Lord, I will, if I have any further material to refer you to, I shall do so in reply.
What about paragraph 54?
Oh, that looks a bit more like it, yes.
Yeah.
that I think.
Yeah, the order will remain in force until or unless the Secretary of State's decide to
Yeah.
revoke it. Yeah.
Yeah, I think that's the one. Thank you very much.
Regulation 27, as your Lordship has already identified, sets out the public policy grounds that the appellant was deported pursuant to. It is worth drawing your Lordship's attention to paragraph 6 of Regulation 27 in the authorities bundle at page 85. Before taking a decision on the grounds of public policy and public security in relation to a person who is resident of the United Kingdom, the decision maker must take account of considerations such as age, state of health, family, and economic situation of P, P's length of residence in the United Kingdom, P's social and cultural integration into the United Kingdom, and the extent of P's links with the country of origin. So all of that, essentially, his private life in the United Kingdom, is a material consideration at the point of the deportation decision. That becomes important later in my submissions. Then, my Lords, Regulation 32, page 89. Person subject to removal. Where a decision is taken to remove a person under Regulation 23(6)(b), the person is to be treated as if the person were a person to whom Section 3, subsection 5, subparagraph A of the 1971 Act, liability to deportation, applies, and Section 5 of that Act, procedure for deportation, and Schedule 3 to the Act, supplementary provisions as to deportation, are to apply accordingly. In short, my Lords, that means administrative removal. So it's open to the Secretary of State at any point to set removal directions. And then subparagraph 4, a person who enters the United Kingdom in breach of a deportation or exclusion order in circumstances where that person was not entitled to be admitted under Regulation 23(1) or 3 is removable as an illegal entrant under Schedule 2 to the 1971 Act and the provisions of that schedule accordingly. Again, administrative removal. So the position is, building on these regulations, once deported, the appellant's not entitled to be admitted to the United Kingdom. If he re-enters the United Kingdom without permission, he is subject to administrative removal.
So why was he allowed in at Holyhead? Because he was on the
He was-
shore already.
My lord, he was detained and sent to prison to serve the rest of his sentence.
Well, I appreciate that, but where was he encountered? On UK soil or?
Yes, in Holyhead, yes.
Right,
and
so he
arrested.
was already in the UK when
Oh,
he was.
yes. On the claim's own evidence, he was encountered in Holyhead. My lord, that brings us on to one of the crucial provisions in the appeal. That's Regulation 33, on the next page, page 91. Human rights considerations. This is a provision that is principally concerned with human rights. This regulation applies to the Secretary of State and tends to give directions to removal of a person to whom Regulation 32.3 applies, so that is satisfied. In circumstances where A, the person has not appealed against the EEA decision to which Regulation 32.3 applies, but would be entitled and remains within time to do so from within the United Kingdom. I deliberately place emphasis on that. So Regulation 33 bites where the person being removed has an in-country appeal right under the 2016 regulations.
Does that apply now? It applied when the appellant was originally removed, because Regulation 32.3 applies to him. But now that he's come back, it's Regulation 32.4 which applies, isn't it?
Lord, it does not apply, and I will take your lordship to the provisions that says it does not apply. So the only time that the appellant had an in-country appeal under the 2016 regulations was the original deportation decision in November 2018. It was certified under this provision so that the in-country right of appeal was taken away from him. At no point since, on re-entry to the United Kingdom or at any point he's been in the United Kingdom, has the appellant had another in-country appeal under the 2016 regulations. And I'll demonstrate why, my lord.
But what about her? Sorry to interrupt, but just what about at that stage when he's come back? Just a Human Rights Act claim.
My lord, I'll come to that. That's the central issue.
Because I mean, I understand the EEA regulations. You have one go, or maybe have one go. But if you then make a separate Human Rights Act claim, and let's face it, a lot of people come over with no rights to be here, and then make a Human Rights Act claim, and unless certified, then they have a right of appeal.
So the relevance of this provision and the in-country part is that this refers to EEA decisions. So it's appeals from EEA decisions, and those appeals are brought pursuant to Regulation 36, which I'll take your lordships to shortly. So the point I make about this provision, Regulation 33, is that at no point since November 2018 has the appellant had an in-country appeal right against an EEA decision. Because the only EEA decision that has been made in respect of him is the deportation decision. And that was the argument before Mrs. Justice Heather Williams, and she accepted the Secretary of State's argument that a refusal to consider an application to revoke a deportation order is not an EEA decision, because it's not removal. And it's not a decision on whether he can be admitted to the United Kingdom, which would be the consequence of revoking. So that did not generate any appeal under the 2016 regulations. And then 33.2 deals, I won't read it out, but it deals generally with a decision that removal pending an appeal would not be contrary to the Human Rights Act. And 33.3 is more specific about the grounds and says that the grounds include, in particular, that he would not face a real risk of serious irreversible harm if removed. So those are two different considerations, 33.2 and 33.3. Models moving to Regulation 34 on the same page, dealing with revocation. Paragraph 2 a deportation order remains in force until the order is revoked under this regulation or for a period specified in the order. 3, a person who is subject to a deportation order or exclusion order may only apply to the Secretary of State to have it revoked on the basis that there has been a material change of circumstances that justified the making of the order. So in other words, you can't make the same application you made in country from out of country post-deportation. You have to rely on the circumstances following deportation to make the application to revoke. 4, an application under paragraph 3 must set out the material change in circumstances relied upon and may only be made whilst outside of the United Kingdom. So once deported, you can't come to the United Kingdom and make an application to revoke. It has to be done from outside the United Kingdom, and that is why the Secretary of State in this case refused to entertain the application. Paragraph 5, on receipt of an application under paragraph 3, the Secretary of State must revoke the order if the Secretary of State considers that the criteria for making such an order are no longer satisfied based on the material change of circumstances. And then, my Lord, Regulation 36, which your Lordship asked me about, is page 93. Appeal rights, paragraph 1, the subject of an EEA decision may appeal against that decision under these regulations. So my Lord Dingemans, that's the answer to that question about the appeal rights under these provisions only relates to an EEA decision.
And thus far, the only EEA decision was the original decision to remove the appellant. Is that
Yes.
right?
Paragraph 10 is the enabling provision for Schedule 2. The provisions of or made under the 2002 Act, that's the Nationality, Immigration and Asylum Act, referred to in Schedule 2 have effect for the purposes of an appeal under these regulations to the first tier tribunal in accordance with that schedule.
Beg your pardon, where are you now?
Paragraph 10, page 94.
Yes, I see, thank you.
And then Regulation 37 over the page. Out of country appeals. Subject to paragraph 2, a person may not appeal under Regulation 36 whilst in the United Kingdom against an EEA decision, and then paragraph D, to refuse to revoke a deportation or exclusion order made against that person. So if the application to revoke was made from outside the United Kingdom, there would be no in-country appeal right against that decision if it's a refusal to revoke the deportation order. So at all stages, the appellant is required to remain outside the United Kingdom whilst this application and the appeal flowing from it are dealt with. And then paragraph G, to remove the person from the United Kingdom following entry to the United Kingdom in breach of a deportation order. So when the Secretary of State makes a decision to remove the appellant, he will not have an in-country appeal right against that removal decision. That removal decision, those removal directions, will be an EEA decision, but the appellant will not have an in-country appeal right against that putative decision. And just to be clear, the removal decision in November 2018 I will describe as the deportation decision. The removal directions that are yet to be set to administratively remove the appellant from the UK will be removal directions, but they will be another EEA decision.
But that decision has not yet been made.
Not yet been made.
Can I just ask you this question? Suppose someone is removed, deported to another country, and in that other country is the subject of serious threats to life, etc. In particular, if you've been engaged in criminality, sometimes might happen, comes back to the UK, then on your analysis of these regulations, illegally because you've been deported before, even though you are the subject of threats outside, and you write to the Secretary of State and say, look, I'm the subject of these threats outside. Secretary of State just says, well, you're going back. And there's nothing he can do in this jurisdiction to challenge that. Is that right?
Well, my lord, that's not quite right, because it's not the full picture. So if he was subject to a threat to his life in a EEA country, he may be able to make a protection claim. A protection claim under Section 82 of the 2002 Act is not the same as a human rights claim. We are here concerned with the human rights claim because Schedule 2 only relates to human rights claims. It doesn't relate to protection claims. So if he were to make a protection claim, that would be outside the scope of the provisions that we're discussing in this appeal.
Right. But I mean, most people would just say I'm the subject of a threat, and might even say articles, rights to life, etc. And the Secretary of State might say, well, that is a human rights claim.
So the normal position is, as I'm setting out, that it all has to be done out of country. The Secretary of State does have a discretion.
But not reviewable in these courts under these regulations.
Not under the EEA regulations, no. I mean, that's pretty clear from the framework.
And I'm sorry to test it, but if you're right, then these courts have no right to interfere. I mean, the Secretary of State may, especially if considering those sort of threats genuine, obviously decide to allow the person in. But suppose perversely the Secretary of State doesn't, then there is no remedy in these courts under the regulations. Is that right? Unless it amounts to a protection claim.
Under the regulations, that's right. There are other remedies.
What would they be?
Well, potentially a judicial review of the Secretary of State's decision if the Secretary of State refused to entertain an Article 3 claim, but also a judicial review based on policy guidance. I was beginning to explain the Secretary of State does have a discretion to consider human rights claims as an application to revoke. And that's in the policy guidance that we have in the authorities bundle.
But you've just shown us that if the Secretary of State decides, well, I'm going to make the deportation decision, it's an EEA decision, and there's no appeal.
Under the EEA regulations, no.
Thank you. Sorry to interrupt.
Well, that brings us on then to Schedule 2, which is the crucial provision for the purposes of the Secretary of State's appeal. At page 105 of the authorities bundle, it has the title Appeals to the First Tier Tribunal. Paragraph 1 says the following provisions of or made under the 2002 Act have effect, and I place emphasis on the following words, in relation to an appeal under these regulations to the First Tier Tribunal, as if it were an appeal against a decision of the Secretary of State under Section 82(1) of the 2002 Act, which contains the rights of appeal to the Tribunal. And then Section 84, grounds of appeal, as though the sole permitted grounds of appeal were that the decision breaches the appellant's rights under the EU treaties in respect of entry to or residence in the United Kingdom. So where an appeal is brought against an EEA decision, this provision means the only ground of appeal that can be relied upon under the regulations is a breach of EU treaties. So it's a restricted ground of appeal for appeals under the 2016 regulations. Now, paragraph 2 over the page is dealing with something different. Paragraph 2 is not dealing with appeals under the regulations. I want to make that clear at the outset of my submissions. Paragraph 2 says, Section 92(3) of the 2002 Act has effect. So Section 92(3) of the 2002 Act stipulates which appeals have to be brought outside of the United Kingdom and relates to certifications under Section 94 and Section 94B. Section 94 we'll come to is where a claim is clearly unfounded. Section 94B mirrors Regulation 33, which your Lordship has already seen. So Section 92(3 of the 2002 Act has effect as though an additional basis upon which an appeal under Section 82(1)(b) of that Act, human rights appeal, must be brought from outside the United Kingdom. So I pause there. That is why I say that this provision is not concerned with EEA decision appeals, it's concerned with human rights appeals. And then A, the claim to which that appeal relates arises from an EEA decision or the consequences of an EEA decision. So, pausing there, although this provision relates to human rights appeals, not EEA appeals, it only relates to human rights appeals that are related to EEA decisions. So a claim to which that appeal arises from an EEA decision, all the consequences of an EEA decision.
And you contrast that with Regulation 36, which talks about an appeal against the decision, the EEA decision. You say
Yes.
that
Yes.
paragraph 2 is wider than simply
Yes.
looking at an EEA decision. It embraces things arising from or consequences of an EEA decision.
And that must be right, because under paragraph 1 of this provision, if it's an EEA appeal, you can only appeal on EU treaty grounds. So if you're dealing with a human rights appeal, it's not under the 2016 regulations. So this provision is dealing with human rights appeals, immigration decisions outside the framework of the 2016 regulations, but they have to be connected to EEA decisions or the consequences of those decisions. So thinking in terms of concentric circles, the inner concentric circle is the 2016 regulation framework. This is the outer concentric circle that catches human rights appeals that relate to the inner concentric circle. And then B, the removal of that person from the United Kingdom has been certified under Regulation 33. The removal and the words has been are subject to different interpretation by the parties in this appeal. In my submission, that is just a factual condition. That the deportation of the person who's bringing the human rights claim that's related to an EEA decision or the consequences of an EEA decision has been certified under Regulation 33 as a matter of historic fact.
Because you say he's only been removed once, and that removal was certified.
Well, yes, and he can only ever be certified under Regulation 33 once, because he will only ever have one in-country right of appeal at the point of the initial deportation decision. Because when he re-enters the United Kingdom following deportation, he doesn't have an in-country right of appeal, so Regulation 33 never arises. So the only removal that can be certified under Regulation 33 is the deportation decision. Now, my lords, may I say a little bit at this juncture about the differences between an EEA decision and a human rights decision. It's common ground between the parties in this appeal that there are two types of decision in play. There's an EEA decision. The only EEA decision in this case was the deportation decision in November 2018. And there's an immigration decision on the 14th of July 2020, which was the refusal of the human rights claim, which prima facie attracted an in-country right of appeal under Section 82(1) of the 2002 Act. Say prima facie because that depends on Schedule 2.
That's the amended Section 82(1), is it? Because it was all amended in 2014, I think.
Yes, and it's now just deals with protection claims and human rights.
Yeah.
May I take your lordships to the statement of facts and grounds in the core bundle at page 260.
260.
60. Lord, yes. This is the claimant's statement of facts and grounds. Paragraph 4.10. The problem for the Secretary of State here is that two decisions have been made. The decision to remove EB, which can only be appealed outside the United Kingdom under the EEA regulations 2016, and the decision to refuse the human rights claim, an immigration decision attracting an in-country right of appeal if not certified. So that's the common ground that I refer to. And then that feeds into the Upper Tribunal judgment at paragraph 48 on page 157. So paragraph 48, Judge Perkins says, as indicated above, it is the applicant's case that there are two decisions here, a decision not to refuse to revoke the deportation order, and additionally a decision to refuse leave on human rights grounds. That actually is a slight mischaracterization of the appellant's case, as I've just shown you. The two decisions are the removal decision and the human rights decision, not the refusal to entertain a revocation application. But the same point applies. There are two types of decision that we're dealing with in this appeal.
And that's common ground.
That's common ground.
Yeah.
The judgment of Lord Justice Sales, as he then was in Ami Taimur and the Secretary of State, 2017, Court of Appeal 353, provides a helpful explanation of the differences between these two decisions. May I ask your lordships to turn to the authorities bundle, page 208. So paragraph 1 of the judgment, just to orientate my submissions. That appeal was concerned with the extent to which an individual appealing to the first tier tribunal against a decision of the Secretary of State to refuse to issue a derivative residence card under the 2006 regulations, the predecessor to the 2016 regulations, but nothing turns on that, is entitled to introduce a distinct human rights claim for leave to remain in the United Kingdom in that appeal. In the decision under appeal to this court, the Upper Tribunal held that the introduction of a new human rights claim in the proceedings before the FTT in this way is not permissible. Then, my lords, can I take you to paragraphs 25 to 27 on page 217. So halfway through paragraph 25, I wish to pick it up. The Secretary of State was not invited by the appellant to take a decision to exercise her discretion under the 1971 Act by reference to Article 8. But even if she had been, any decision made on such an application would not have been an EEA decision, as defined. It would have been an immigration decision within the scope of Section 82(1) of the 2002 Act. A right of appeal under Regulation 26(1) is only a right to appeal against an EEA decision. Regulation 26(1) creates no right of appeal against any other kind of decision. In particular, it does not create a right of appeal in relation to a claim for leave to enter or remain under the immigration rules or by exercise of the Secretary of State's discretion by reference to Article 8. Where the Secretary of State makes a relevant decision by reference to the immigration rules of Article 8, that is an immigration decision with a separate right of appeal under Section 82(1). In my judgment, the natural meaning of the phrase may appeal under these regulations against an EEA decision, as used in Regulation 26(1), is that the appeal right thereby created is in respect of an EEA decision and is to proceed by reference to grounds of claim and grounds of appeal of a kind recognised as creating entitlements under the regulations themselves, reflecting as they do entitlements under EU law. My lords, may I make 2 points before I proceed? Firstly, that is a direct answer to my Lord Dingemans' question about human rights claims not having a right of appeal under the 2016 regulations. And secondly, Lordships will recall Schedule 2, Paragraph 1, which says expressly in the context, in our context, that an appeal under the 2016 regulations, the only ground of appeal is a breach of EU treaties. So Schedule 2.1 is more specific about what Lord Justice Sales says there.
So if there are two decisions, one EEA, right, you have to go out of the country to do that. Why, in the absence of certification of the human rights decision, didn't he have a right of appeal in this country?
My Lord, because he's caught by Schedule 2, Paragraph 2, and I'll come on and make submissions about that.
So you say it's the effect of Schedule 2, Paragraph 2?
My Lord, yes.
Yeah, thank you.
But because what he's done is exactly what Lord Justice Sales says you should do. He hasn't tried to broaden an appeal by invoking Article 8. He's made an application to the Secretary of State to rely on Article 8. That's what Lord Justice Sales says you should do in paragraph 1 of the judgment.
My Lord, he did two things. One, he made an application in country to revoke the deportation decision.
Yeah, well, that you
and
say,
he left it at that.
Yeah. Your
Lordship would be right. But then he also made a claim on in his claim of the 22nd of May 2020, a human rights claim, and that was this correspondence following the Secretary of State's decision to refuse to entertain the deportation order between the appellant and the Secretary of State, where the appellant insisted that he had made a human rights claim also. That is what led to the 14th of July decision. The Secretary of State accepted he would have to consider the human rights claim. So he did two things.
Yeah.
And then paragraph 30, Lord Justice Sales says this, and in my submission this is important. Where a person applies to the Secretary of State for some right or benefit under the EEA regulations based upon entitlements under EU law, such as a derivative residence card, the Secretary of State made reference in her decision to Article 8, say by mistake or because the applicant had referred to Article 8 in the course of filing his application form under Regulation 18A, as well as to his entitlements under the EEA regulations, that would be irrelevant surplusage. The Article 8 section of the decision in such a case would not form part of the relevant EEA decision, and there would be no right of appeal under Regulation 26 in respect to that section of the decision. My Lord, I pause there. That's the point that you make, that when the Secretary of State initially just refused to entertain the application to revoke, that would have fallen within that those sentences. But Lord Justice Sales continues about 5 lines down towards the right-hand margin in brackets. Depending on the facts, if the Secretary of State did happen to address Article 8 arguments in her decision letter in such a case, it might be possible to say that the Secretary of State had waived the requirement for an application form to be completed in respect of her exercise of her residual discretion of the 1971 Act by reference to Article 8, and that she had then made 2 decisions, an EEA decision in relation to entitlements under the EEA regulations, and an immigration decision within the scope of Section 82.1 of the 2002 Act, with distinct rights of appeal under Regulation 26.1 and under Section 82.1 respectively. Nothing of that kind happened in that case. So, my Lord, it did happen in this case. 2 applications were made, 2 decisions were made.
Yep.
Well, 1 non-decision and 1 human rights decision.
Yes.
And so there are 2 types of decision attracting 2 different rights.
So the position you've got to now is that the refusal of the human rights claim was an immigration decision.
Lord, yes. But one that is caught by paragraph 2 of Schedule 2 because it relates to the consequences of an EEA decision. So it's in the outer concentric circle. The consequences of an EEA decision include 1, that a deported person is not entitled to be admitted to the United Kingdom and is subject to administrative removal. And 2, that an application to revoke the deportation order must be made from out of country. Those are 2 obvious consequences of the only EEA decision in this case. Well, that brings me to the central issue and my submissions on the operation of paragraph 2 of Schedule 2 and how it removes the in-country right of appeal in the human rights claim. The central issue could be characterised in this way. Does paragraph 2, schedule 2, apply to human rights decisions which are not made at the same time as a particular removal decision? In other words, can it apply to a human rights decision that is made sequentially,
Well, not only sequentially,
but at a different time?
different grounds.
Yes. The Secretary of State submits that paragraph 2 of Schedule 2 applies to human rights claims whenever they are determined, as long as they arise from an EEA decision or the consequences of an EEA decision. Now, may I begin the central issue by identifying the appellant's argument below and how the court accepted that argument, and then by showing why those arguments and the decision was wrong. My lords, may I take you to the appellant's skeleton argument below, which is in the core bundle, page 208.
$208.
My lord, yes.
Thank you.
I wish to refer to 3 paragraphs. Firstly, paragraph 4.1.8, and 9 lines down, the new sentence at the very left-hand margin. The appellant submitted, what is being challenged now is refusal of the Secretary of State to allow the appellant to remain in the United Kingdom on the basis of the refusal to revoke the extant deportation order. And the appellant accepts for this claim that any EU-based claim appeal to that would have to be pursued out of country, and that the Secretary of State has not made an EEA decision under the 2016 regulations. If a broad reading of paragraph 2.1a is given, in brackets, is human rights claim arises from a previous EEA decision, then the appellant accepts that the condition is satisfied. However, if paragraph 2.1a relates to an EEA decision made at the same time as the human rights claim, then it is not satisfied here. So the appellant is saying that if paragraph 2.1a is read as requiring the human rights claim to relate to an EEA decision made at the same time, then the appellant's not caught by it, because the human rights decision was not made at the same time as the EEA decision. So the appellant's case starting to emerge here is that paragraph 2, schedule 2, requires the related human rights claim to have been decided at the same time as the EEA decision. That's the appellant's case being developed here. And the appellant explains this in the paragraph above, in 4.1.7, but at the top of the same page, on page 208. So the intention in this paragraph is to make further separate certification under section 9494B unnecessary, because certification under regulation 33 has addressed the issue of whether the claimant can remain in the UK whilst any appeal is pursued. As such, the Article 8 appeal against an adverse decision cannot commence until the appellant leaves the United Kingdom in the same way as would be the position if section 94, section 94B certification had been issued. The end result is that the appeal under EU law and the appeal under Article 8 are both resolved out of country, subject to the appellant being able to return to the UK to present his appeal under Regulation 41. So the appellant says the purpose of paragraph 2, schedule 2, is when the decisions are made at the same time, it's unnecessary to certify under section 94B, because that's the effect of schedule 2. But importantly, the appellant says that's the only effect of Schedule 2, paragraph 2, and that's the difference between the appellant and the Secretary of State. Then over the page, paragraph 4.1.9. As such, the key flaw in the Secretary of State's use of paragraph 2.1 here is to fail to appreciate that the removal referred to in paragraph 2.1b is the specific proposed removal against which the human rights claim and EU claim is being directed to, not simply against a separate, different removal in the past. Claims under the ECHR and EU law are made against an intended removal. In this situation, Regulation 33 certification would avoid a separate certification under Section 94 in relation to a human rights claim, but only if it was made against the relevant claim objecting to removal. So again, the appellant's clearly making the case that on their reading, paragraph 2, schedule 2, only bites in relation to human rights claims if they are decided at the same time as the removal decision.
Well, I understand that point, but surely it can't just be a question of timing. It must also be a question of grounds, mustn't it?
My Lord, yes, because it has to arise from the EEA decision or the consequences of an EEA decision. And my Lord, I accept that, and it's my case, that paragraph 2, schedule 2 is not restricted to human rights claims which are decided at the same time as the removal. Human rights claims can be made whenever, and they often are. And my Lords, may I now demonstrate how this fed into the Upper Tribunal judgment. Page 156. Paragraph 44. Second sentence. Mr. Kuba maintains that the certificate relates to a particular removal, and so subsequent removal is not automatically certified, or more accurately, the existence of a certificate in contemplation of a particular removal does not transfer to any subsequent, not hitherto contemplated, removal. I find that the words of Regulation 33 give considerable support to this contention. It applies where the Secretary of State intends to give directions for the removal of a person. The Schedule 2 certificate cannot be divorced from a particular removal. That might mean, as could be the case here, that the certificate achieves little because the appellant left voluntarily. It might be that he left voluntarily because he knew that he could not appeal. Be that as it may, he left and returned, and if the respondent is to give effect to the deportation order that clearly exists, and the applicant is disinclined to go voluntarily, the respondent will have to make a further order, and if that leads to a further application, then the respondent can, if so minded, refuse it and certify it, under Schedule 2 if the decision flows from an EEA decision, and under Section 94 if it flows from a human rights decision. It follows on this point that I find for the applicant, the respondent was wrong. She cannot rely on an existing Regulation 33 certificate issued in contemplation of a particular removal to make the applicant go out of country to appeal against a subsequent decision leading to the applicant's later removal. Such an application could easily depend on an entirely different set of facts. And then he goes on to refer to the fact that the existence of Section 94 discourages him from interpreting Schedule 2 any wider.
Could I ask you this? Would you dispute the proposition that the later human rights application could easily depend upon an entirely different set of facts from those that existed when the application was first certified?
Lord, yes. They could depend on a material change of circumstances.
So, when you say yes, I understand you to be accepting the proposition rather than disputing it.
I accept that a later human rights decision could be based on a different set of facts, yes.
Thank you.
But I think you don't disagree with Mr. Kuba's submissions in paragraph 44. You just say it doesn't matter because there was only ever been one removal. That removal was certified, and that is a precedent fact which is necessary to bring Schedule 2, Paragraph 2 into play.
My Lord, I do disagree with it, because what's being said by the judge there, and accepting Mr. Kuba's submissions, is that for the human rights claim to be caught by Paragraph 2 of Schedule 2, it has to have been made at the same time as the certified removal. The difference between us is, I don't accept that the human rights claim has to have been made, or the decision on the human rights claim has to have been made at the same time as the EEA decision.
No, that I understand, but you're not saying that the existence of a certificate in contemplation of a particular removal does transfer to a subsequent removal. You say that's really got nothing to do with anything.
Quite. The Regulation 33 certificate is just a factual precedent.
Yeah.
Yes.
I think that's what I was suggesting to you.
Oh, yes.
I think
Forgive me
that's
for
your
misunderstanding.
argument.
Can I just ask for, while we're on this paragraph 2 and what it means, it may only be me, but it's slightly curious, trying to read paragraph 2.1. Can you help a bit with that? I mean, it's 106 of the bundle, of the authorities bundle.
So paragraph 2.1.
Is of the schedule 2.
Yes.
Paragraph 2.
Yeah.
And then little 1. Section 92(3) of the 2002 Act. And that is, section 92 is the one that gives the rights of appeal.
My Lord, section 92 is at page 23.
Yeah.
It dictates whether an appeal is in country or out of country.
Yeah.
And so if a person's in the country when they make a human rights claim, then the appeal will be in country unless it is certified under sections 94 or 94B, in which case it becomes an out-of-country appeal. That's the effect of section 92.
So that means, so effectively saying, out of country, this will be an out-of-country appeal, as though an additional basis upon which an appeal under section 82(1)(b) of that Act must be brought from out. Were that, I mean, does it make sense that the paragraph?
So, my Lord, in my submission, what the paragraph is achieving is, or the purpose of this paragraph is to achieve equal status to a certification under section 94 or 94B, because it's modifying section 92 where these conditions are met, and there are two conditions, A and B. And if they are met, then it has the same effect as paragraphs 94 and 94B, as section 94.
Yeah, I mean, my question was even more basic than that. Does it read grammatically?
So, section 92, which sets out the circumstances in which an appeal is out of country, has effect as though an additional basis upon which an appeal under section 82 must be brought from outside the United Kingdom, were that, in my submission, it does make sense because it's modifying section 92 to include a third basis upon which an appeal must be brought from outside the country.
I think you are reading section 92 as, in effect, providing a basis in section 92(3), the basis on which an appeal must be out of country is either that it's been certified under 94(7) or 94(b), or, see paragraph 2.2 of the regulations, it relates to an EEA decision or the consequences of such a decision and the removals being certified under paragraph 33.
Lord, absolutely.
Right, thank you. So sorry about that. It was, for a while I was wondering whether it should be where that, but anyway, it doesn't really matter.
But, my Lord, I've spent hours reading this provision.
No, well, that's why I asked you.
It could have been drafted more clearly, I think. My Lordships, that brings me then to 7 submissions as to why the appellant and the Upper Tribunal were wrong. Firstly, a removal decision is an EEA decision. Paragraph 2, Schedule 2 is not restricted to EEA decisions. but applies to human rights claims which arise from the consequences of an EEA decision, not, as the appellant would have you accept, the EEA decision to remove. Secondly, the removal of that person from the UK has been certified under Regulation 33. That's paragraph 2, 1b, can only ever refer to the initial deportation decision. Because Regulation 33 only applies where there is an an in-country right of appeal. But Regulation 37, 1g, renders any appeal against administrative removal following unlawful re-entry an out-of-country appeal. So subsequent removals cannot be certified under Regulation 33. The appellant is wrong to suggest otherwise at paragraph 4.1.7 of his replacement skeleton.
4.1.
Thirdly, human rights claims can be made at any time, and decisions on them are often not made at the same time as the decision which is said to interfere with the human rights. The facts of this case are a prime example. Another example that the court will be familiar with are 11th hour human rights claims against flight directions, and the substantive decision was taken months ago. Human rights claims can be made at any point in the process. It would be an incorrect reading of paragraph 2, schedule 2, to say that those human rights decisions are not caught by paragraph 2, schedule 2, because they were not decided at the same time as the EEA decision. Fourth, the obvious purpose of paragraph 2, schedule 2 is to avoid a dichotomy between an EEA appeal being out of country and a related human rights appeal being in country. If that were the position, it would render enforcement of the 2016 regulations unworkable, because an otherwise removable deportee could not be removed because of a pending human rights appeal. Fifth, all of this comes into sharp focus in this case when the Secretary of State does take a decision on administrative removal. That will be an EEA decision, see Regulation 37(1)(g), with an out-of-country appeal right. If the Secretary of State made a human rights decision at the same time and refused the human rights claim, on the appellant's case, there would be an in-country right of appeal, and paragraph 2, schedule 2 would not apply because that administrative removal decision could not be certified under Regulation 33. Because the appellant says that the human rights claim has to be decided upon at the same time as the EEA decision, which is certified under Regulation 33. That can't happen again. So every time a removal decision is made, if the appellant is right, they could defeat the enforcement of the 2016 regulations by making an in-country human rights claim.
But if the Secretary, just remind me, if the Secretary of State decides to remove somebody because they have entered the United Kingdom in breach of a deportation order, that decision can never be certified under Regulation 33.
Lord, that's correct. So that's the problem with the appellant's argument.
Yeah.
Can I just ask this follow-up? If you accept there are two decisions, which I think you do, one is the the EA decision and one is the immigration decision. And you point to the absurdity of having an in-country right of appeal and an out-country right of appeal. Well, what was to stop the Secretary of State certifying the immigration decision under Section 94 or 92, whichever one it is, to say you can only appeal out of country?
Well, it would not be needed, if I'm correct.
I appreciate that, but a lot of your argument, and I will understand why a lot of your argument is this way, a lot of your argument is this will drive a coach and horses through the regulations, this is absurd, whereas one might have thought that a pretty easy answer was for the Secretary of State just to sign a certificate saying out of country only.
Well, my Lord, as you'll be aware, that's my argument on Section 31(2)(a). But my argument here is that the decision maker was correct to rely on paragraph 2, schedule 2, because for the reasons that your Lordship identified earlier, it modifies Section 92 of the Act and its specification of what are out-of-country appeals to add to Section 94 and 94B, paragraph 2, schedule 2. So why does the decision maker need to certify under Section 94 when the automatic consequences of paragraph 2, schedule 2 are the same?
What do you say the automatic consequences are? Well, one answer would be to avoid this type of argument.
Well, my Lord,
But
certification.
I accept that's not a legal answer.
Certification under Section 94, they're always controversial. And my learned friend says in his written argument, if this is certified under Section 94, they bring a claim for judicial review. Actually, the automatic consequences of paragraph 2, schedule 2 are more straightforward. Sixth,
I think you owe us 2 more reasons.
Lord, yes, and then I'm finished on my appeal. Sixth, it is not surprising or objectionable that such human rights claims should be pursued from out of country, given the mechanism for revoking deportation orders where there is a material change of circumstances since deportation. It is not as though the appellants are being deprived of their procedural right. It's the argument is about the place from which they do it, against a background that they have been deported, in this case, 3 months ago. Seventh, the final sentence of paragraph 45 of the Upper Tribunal judgment, and perhaps I should take your Lordships to that. It's in the court bundle, page 156. Paragraph 45, we've been there once, the final sentence. It's quite a long sentence, it starts in the middle of the paragraph. Be that as it may, be left and returned, and if the respondent is to give effect to the deportation order that clearly exists, and the applicant is disinclined to go voluntarily, the respondent will have to make a further order, and if that leads to a further application, the respondent can, if so minded, refuse it and certify it. And it's this bit. Under Schedule 2, if the decision flows from an EEA decision, and under Section 94, if it follows a human rights decision. That rather demonstrates that the judge did not understand the purpose of paragraph 2, Schedule 2, because paragraph 2, Schedule 2 relates to human rights claims, not EEA decisions. It refers to human rights claims that arise from an EEA decision or the consequences of an EEA decision. So the distinction that the judge is drawing between Schedule 2 and Section 94, that one does and one doesn't arise from human rights considerations, is wrong. It's a misunderstanding. My Lords, those are my submissions on the cross appeal. Is it convenient for me to deal with my reply on the appellant's appeal now, or would you rather hear from the appellant?
I think it's probably better if we hear from Mr. Kuban now on the appeal, on the cross appeal, and then he can open his appeal on refusal of relief.
Lord, yes.
Yes, Mr. Kuban.
My Lord, if I can address you in relation to the cross appeal. In my submission, essentially, the judge below was correct for the reasons he gave. The essential point to appreciate, as he did, was the point regarding the different types of removal and the different removal decisions that have happened. And it's not simply a question of timing, as Lord Justice Arnold pointed out, it's a question of content. What was crucial to understand in terms of the interrelationship between Schedule 2 and Para 2 and a human rights claim is what it relates to. What this related to was a removal that was due to take place, and that was long after the previous removal that had taken place and was the basis of the Regulation 33 certificate. And in my submission, that's important to understand in terms of the crucial issue. And that's why he's concerned in paragraph 46 of his judgment about the way in which the Secretary of State's interpretation would mean a Regulation 33 certificate having an effect long after it was made, despite a change of circumstances. And that's why I say that in relation to this case, the correct reading is that. And when one looks at focusing on the interaction of the provisions in the EEA regulations and also the rights of appeal under the human rights sections under Part 5 of the 2002 Act, which you haven't been taken through in any detail, but I will take you to them in order to understand the argument. What I would just flag up at this stage is clearly you've had a lengthy work through of the EEA regulations. What's going to be crucial to bear in mind in my submission is the wording of Regulation 33, which was the basis for the original removal. And if you're in the authorities bundle, Regulation 33 is at page 91 of the authorities bundle. And I'm sorry. If you're at Regulation 33, you'll see there that there's no dispute that this is a certification power that allows for an interim removal in relation to an appeal that exists in relation to an EEA decision. So in the context of this case, in the history of this case, this was the power legitimately used at the initial stage in 2018 when the deportation decision was made. And it was in relation to the removal of that person. So the focus, you can see from the wording of paragraph 33.1, it's focusing on when the Secretary of State gives directions for the removal of a person and he can appeal. And the focus is on that removal and whether making that removal, despite the appeal process not having been concluded or having been fully resolved, there would be a breach of human rights.
And that applies to your client's original removal.
Exactly, yes.
And that is the only removal to which it could apply?
Yes, that's right, here, in relation to the situation that we're now in, because there hasn't been, as we've discussed, and I'll go through in a moment, an EA decision currently. That hasn't been made. So it was only made then, at that time, and that's the trigger for the use of Regulation 33.
And if the Secretary of State were to make a decision to remove your client now, because...
Well, he has made a decision to remove him. And that's why that's triggered the human rights claim and the human rights decision.
But then the decision to remove somebody because they're in breach of a deportation order,
yes,
under Regulation 37, only gives rise to an out-of-country appeal, doesn't it?
My lord, that's where we need to, and I will take you to Part 5, because what this case requires, and what, in my submission, Upper Tribunal Judge Perkins did do, was understand the relationship between the two systems of protection regarding rights of appeal. Simply put, and I will make the point, and Lord Justice Dingemans made the observation, but I say it has more force than simply an observation of practicalities. It does have an observation that has legal force, is that in this case, properly understood, as Upper Tribunal Judge Perkins did, the correct root or source of the legal power to prevent an in-country right of appeal under human rights grounds was Section 94. It wasn't deployed. That's the error that has happened in this case. And that's why we say paragraph 2 of Schedule 2 did not apply to the circumstances of this case because it related to a new removal that was out with the content of the Regulation 33 certification, which happened much earlier in time on a different set of facts. That's the crucial point to understand in terms of not simply the issue of time, but content. And you've probably read through the papers, but the point that the appellant was making was by this time, when he had returned, he had faced hardship on his return. That's why he was returning. That's why he was making a claim. Now, simply put, our case is that in that scenario, there was nothing stopping the Secretary of State from deploying Section 94, and that was the correct legal route. And one of the odd consequences of the Secretary of State's position here is even now, it would be the case that there's a dual position, that you could either use Section 94 or this section, which in itself shows why the analysis is wrong, because there wouldn't be two provisions dealing with the same issue.
Not sure an argument for redundancy gets much traction given the complexity of immigration legislation, does it?
Well, my lord, I can well understand that, but I think what I'm trying to get to is Judge Perkins did understand the careful intersection between these to make the point that the crucial difficulty, and I think Lord Justice Dingemans made the point clearly, is that if you have a case where you've got a different set of facts, and probably quite serious set of facts, I mean, take it as far as Article 3, the idea that a past certification based on Regulation 33 on a different set of facts determines that you don't have an in-country right of appeal on human rights can't follow. And that's precisely why the protection of Section 94 is there for the Secretary of State. The Secretary of State can say, yes, I know you've made another claim. I know you've made a very serious allegation about Article 3, but I don't accept that allegation. And I don't accept that allegation to the point where I say that it can be certified under Section 94 as clearly unfounded. And that's the point, that it would meet that situation. But to try to use, and this is one of the, obviously, the points of issue that was in the court below, is how far does the previous Regulation 33 certification go to a different claim that's made subsequently with different content? Now, in order to understand that interaction...
Can I just explore where this point goes to? Because as I understand it, the point you've just made is the way it's relevant is you say we don't need to give a strained interpretation to Schedule 2, Paragraph 2, because we needn't be worried that the Secretary of State would be left naked, because she wouldn't be left naked. She has another power at her disposal, which is perfectly apposite for cases such as the present. But while that sort of argument clearly has a place, one still has to come back to the question, well, okay, even if we don't give a strained interpretation to Schedule 2, Paragraph 2, one still has to say, well, what do the words mean, having regard to their purpose?
Indeed, indeed, and that's right. And that's exactly why I made the point that Judge Perkins picked up in one of the paragraphs about the purposive construction approach to this in terms of what it's meant to be doing in terms of extending the certification power under Section 92. And the point is it relates specifically to an EA decision and to a removal at a certain point in time. That's why it had play in the original situation, but it doesn't have play in subsequent claims. Accepted, he had to entertain. So if I can just make some nutshell points here, as far in terms of where we've got to, I think it's clear and it's not in dispute that one, the appellant made two claims to the Secretary of State when he returned. under EU law and human rights. 2, the Secretary of State said you can't have an in-country consideration of your EU points. I accept that. But he did say that you can have a consideration of your human rights claim. And that's what he accepted he needed to do. The reason for that is as I'll take you to it in due course, is that the appellant had made a human rights claim and the Secretary of State was required to consider that because it was in contemplation of removal. That's section 113 of the 2002 Act, which I'll take you to. But he accepts that he had to consider the human rights claim. Thirdly, the question then was, having considered the human rights claim, what are the consequences of that in terms of the legislative provisions? And if he's made a human rights decision, he has to appreciate the interaction between the primary legislation regarding rights of appeal under human rights claims and these regulations where there was past historical certification. So what I would like to do now is go to the 2002 Act just to help understand how this figures in the context of what the 2002 Act says about human rights claims and appeals, because that's obviously the other part of the legislative equation. You've been through the EEA regs, the other side, which in my speech are actually more relevant to this case because the Secretary of State accepts that he's made a human rights claim. He has to work out what to do with that claim once it's been rejected. So if you're in the Authorities Bundle tab 3, you will have the 2002 Act, which is relevant for the purposes of the appellant claim that he made. So if I can just track through this in terms of the relevant parts of it, in terms of understanding how this works, for the purposes of the 2 distinct claims and the distinct decisions made by the Secretary of State. If you're at page 17 of this bundle, you'll see there that there is, in relation to section 82, there is there the reference to claims and where an appeal can be made. So you'll see there, in relation to this, that a person may appeal in relation to the tribunal where it's 1B. That's the section that's relevant here for our purpose. And you'll see there the Secretary of State has decided to refuse a human rights claim made by P. Now that's happened in this case. I don't think there's any dispute about that. And if you need the reference, there is the decision itself, which does make that decision where it's been refused, 14th of July 2020. And in terms of the definition of the human rights claim, you'll see that
113.
yes, that's right. Your Lordship is right, and it's marked there at page 42. Human rights claim means a claim made by the person to the Secretary of State at a designated place that to remove the person or require him to leave the UK would be unlawful under Section 6. And you're familiar with Section 6 of the Human Rights Act, which protects human rights. So that's what he has done. He's made a claim and he is now looking to what remedy there is. And this is telling you what the situation is in regards to rights of appeal. So there is a right of appeal, and in relation to that right of appeal, you can see there that under the grounds of appeal, an appeal, sorry, I'm looking at section 84, grounds of appeal, page 19, and it's section 84, subsection 2. An appeal under section 82(1)(b), which we've just looked at, refusal of a human rights claim, must be brought on the ground that the decision is unlawful under section 6 of the Human Rights Act. And then we move on to section 92, and it's section 92(3) that's relevant. Now, my lords, there was a glitch in the contents that you had in relation to your bundle because of the constant changing of the legislation here. You haven't got the version that you need to have is the version that was in force at the time. So I've made copies of this, and I've replaced the pagination to assist with providing that. Apologies for that, but I can provide it to you. I provided copies to my own friend.
So this is section 92 as it was at what date?
At the time that the decision was made in relation to this case. The important point is that it's section 92 subsection 3, which was modified, and you've got the modified version, but this is the correct version. And it's section 92.3. Looking at my rebranded 23A,
Yeah.
you've got 92.3, and in the case of an appeal under section 82.1b, where the claim to which the appeal relates was made while the appellant was in the UK, the appeal must be brought from outside the UK if A, the claim to which the appeal relates has been certified under section 94.1 or 97 or 94b, certification of a human rights claim, and then there's other sections, and then it says, as is relevant otherwise, the appeal must be brought from within the UK. So what it's doing there is indicating the position regarding what the effect is regarding any appeal, and the location of where it's made and the effect of it in terms of certification. So if it's made from the UK, and unless it's certified, then it can be pursued in the UK, and it must be pursued in the UK. And then section 94 itself is the certification power, which is page 24. And that's the discretionary power to certify a protection claim or a human rights claim. Looking at section 94.1 there. And then section 109.
Well, 94.1 is a basis on which the Secretary of State may certify a human rights claim as being clearly unfounded, and that would appear to apply to any human rights claim.
Yes.
Section 94B, on the other hand,
Yes.
is a different power of certification.
Yes.
And that enables the Secretary of State to certify that removing P pending the outcome of an appeal would not be unlawful under Section 6, which is on the face of it, a rather lower test.
Yeah, the point of the two sections is they deal with different powers and their effects. So section 94 prevents you from starting a claim at all in the country. You have to start the claim out of country.
94.1, sorry to interrupt, do you mean 94.1?
Yes.
Yeah, because you just said 94, but they're both...
Sorry, I apologise. Yeah, 94. When I...
No, I thought I understood, I just wanted to clarify. Yeah. So section 94.1...
Yeah, 94.1 prevents an appeal being instituted in the UK. It has to start out of country. That's the effect of a clearly unfounded certification.
Doesn't that mean that you can't have any appeal?
No, you can have an appeal, but it would be out of country, and that's the effect of clearly unfounded certification. So, if you in this scenario, the effect of certification would be he would have to institute and pursue his appeal in Portugal, not here.
Isn't that 94B?
That's
No, 94B is dealing with the situation where if you have an in-country right of appeal, and 94B, my lord, is the equivalent of Regulation 33, because what it's doing is permitting the Secretary of State to temporarily remove somebody whilst an appeal has been instituted but hasn't been determined.
Well, wait a minute. If you are certified under 94.1 as being clearly unfounded,
Yes.
that takes you back to 92.3a, which tells you that the appeal must be brought from outside the United Kingdom.
Yeah.
If you are certified under 94b, you may be certified either when the appeals process has not been begun, or after it's been begun but hasn't been exhausted. And if you're certified under 94b, you are again thrown back to 92.3, and your appeal must be brought from outside the UK.
No, my lord.
No?
that-
Well,
no.
isn't that what it says?
No, because what it's dealing with is the situation where somebody can pursue an appeal, but what it's dealing with is the situation of an interim removal pending the resolution of that appeal.
Well,
Because if you look to the wording of 94b2, page 28, the Secretary of State may certify the claim if the Secretary of State considers that despite the appeals process not having been begun or not having been exhausted, pending the outcome of an appeal in relation to P's claim would not be unlawful under Section 6. So,
but then if you ask, I would have thought, then if you ask, well, where does P's appeal have to be made? 92.3 says that where the claim was made while the appellant was in the UK, the appeal must be brought from outside the UK if the claim has been certified under Section 94b. So if there's a 94b certificate, you have only an out-of-country appeal. Isn't that the straightforward reading of it?
no, my lord, that isn't. I think, I mean, the 94b was looked at authoritatively by the Supreme Court in the Chiari and Bindlos case. I haven't got that with me, but the point of distinction between the provisions is that 94b is intended to be an interim removal provision, which allows removal pending the resolution of an appeal.
But at all events, for our purposes, we don't need to worry about
Yeah.
the distinction between 94b and 94.1.
No. My lord, then the other section that's relevant to note in relation to this section is section 109 of these provisions, and in your this is again one that was updated. It's page 40, but I've made copies of the correct version, and this relates.
That was the regulation making power.
Yes, that's right. Yeah. I've just made copies of that, and again, I can provide that to you again. I don't know if Fred has it. It's been renumbered. It's simply the regulation making power for the purposes of the EEA regulations.
Yeah.
So they exist for that purpose.
So the regulations were entitled to disapply or modify.
Yeah. But in relation to that, then the question then goes back to what was intended by Para 2 and Schedule 2 in the light of previous certification under Regulation 33 and in the light of a new human rights claim being made. So if we go back to the wording.
Going back to Schedule 2, are we?
Yes. My lord, just before we go back to Para 2 of Schedule 2, I just want to reference Para 1 of Schedule 2 and what Para 1 is doing. Sorry, this is page 105 of the authorities. If you're at page 105, you will see there under the heading Schedule 2, Appeals to the First Tier Tribunal, the essence of Para 1 is to provide a read across of the appeal and grounds considerations that would apply to a Section 82 appeal under the primary legislation, which we've just been through in terms of Part 5. So what it's seeking to try to do is have some uniformity in the approach to the issues and grounds that an appeal would have under Section 82 of the 2002 Act and read it across to the EEA regulations in terms of the content of those appeals. The only thing that I would add in relation to my learned friend's observation in relation to the Mertimore case and these is that it isn't simply the case that if you do make an EEA regulations decision and that there is an appeal, that it's limited to EEA issues, because there can be circumstances where a human rights claim can be considered, and that's by virtue of a Section 120 notice, where the Secretary of State gives a notice asking an individual to put forward all considerations that they want to have considered for the purposes of their appeal. And if I can just give the reference to that from what Lord Justice Sale said in Mertimore, that was in tab 9 of the authorities bundle. I'll just make a quick reference to it so you can understand that. I wanted to make the point that it's not simply one where there is that raw distinction in terms of the position.
It's paragraph 38 that he deals with.
Yes, absolutely right, my lord. Yeah. So he's just making the point that there are scenarios where even in an EEA regulation case, even where there is that general modification through paragraph 1, you can still deploy arguments regarding Article 8 or human rights. The problem in that case was that it was an EEA case with an EEA appeal where the appellant was trying to simply add on an Article 8 claim when there hadn't been a Section 120 notice. And the point being made was, in that scenario, that can't work because of the careful provisions that have been made for when a discrete and different set of protection can come into play. So if we track back to page 106 and paragraph 2, in my submission, Judge Perkins below was right to focus on the specific elements that were required in order for this to have impact. And what he focused on was the link between the EA decision and the removal, in particular, the EA decision at 21A and the removal at 21B.
Well, I'm wondering about that. And I understand, obviously, you say the Upper Tribunal was right for the reasons it gave. I've got that point. But I've been trying to identify what is the real issue which we're trying to decide on this cross appeal. And at the moment, it seems to me at least an important question is, at least having regard to the way Mr. Howes puts his case, is, well, what is the ambit of paragraph 2.1a? Because his argument, as I understand it at the moment, is he says, well, the claim is one that arises from an EEA decision or the consequences of an EEA decision. Now, that seems to me to give rise to an issue of statutory interpretation, which is, well, what is the breadth, the proper breadth of interpretation of the words arises from an EEA decision or consequences of an EA decision? Because at the moment, the way I understand your case is you say this has got nothing to do with the EA decision. You say the claim is the human rights claim. Your argument is that it's based on subsequent facts after the original EA decision.
Yes.
And so therefore you say, well, it doesn't arise from an EA decision or the consequences of an EA decision.
Okay.
Now, looked at in that way, it seems to be an argument about the breadth of subparagraph A, and it doesn't really matter for those purposes how you interpret subparagraph B. Now, have I got that right or wrong?
Well, look, I think that's mostly right, but I think because of the way it's worded and the crucial addition of "and," these things need to happen at a particular point in time, and they are required as two contingent conditions. So you're absolutely right in terms of the analysis, which is the issue, and which is the issue that we've raised, and that was the issue that Upper Tribunal Judge Perkins was interested in, is how far can you stretch the meaning of an EA decision that was made in the past to impact on a human rights claim for the purposes of this to bite?
What do you mean by at the same time?
Well, my lord, my point here is that there's no dispute that there is no EEA decision at the current point at which this human rights claim has been made. What there has been, there's no dispute that has been a historical EA decision. But my point is when you link A and B, it's important to understand the nexus between the making of an EA decision and the removal, the definite article in B. Because there hasn't been an EA decision here, that's one aspect that comes into play. Trying to rely on a historical EA decision, which has a real disconnection with the Article 8 claim subsequently made, is the first problem. The second problem is that the removal that we're talking about is a different removal. We're talking about a different removal which is happening now as a result of the rejection of the human rights claim.
So is this a fair summary that you say it's both A and B are not satisfied in this case? A, because what you're complaining about is what happened in Portugal, and true, that is after the EEA decision, but it wasn't a consequence of it. It was a consequence of being lonely and unhappy in Portugal. I hope I put that at least fairly for the purposes of this. And then you also say you don't satisfy B because you say that that refers to a different certification.
Yes, my lord, that's right. And can I just add that the point here is that the focus of what's going on here is not the consequences of an EA decision, it's the consequences of removal action subsequent to the rejection of a human rights claim.
But your client's removal now
Yes.
could not be certified under Regulation 33.
My lord, I accept that because the framework for that to occur doesn't exist.
Right. So
What does exist is a certification power clearly under Section 94.
that I understand. So in what circumstances could the two cumulative conditions in paragraph 2.1 be satisfied? And I thought your answer to that was they can be satisfied if the immigration decision and the EEA decision happen at the same time.
They were satisfied at the time of the original decision.
Well,
That's when the deportation decision was made.
Have I got that right?
Yeah, my point is, it's
I'm sorry. The original decision to deport
was an
I
EA
understood-
decision. Yeah.
Sorry,
It was an EA decision.
it was an EEA decision.
Yes.
As I understand it, that was the only decision made at that time. There wasn't an immigration decision because at that time there was no human rights claim.
No, there was a human rights decision as well.
Was there?
Yeah, if you look at the decision, it rejects the human rights claim.
Well, that's because Regulation 27 requires these considerations to be considered, but it's still an EEA decision, is it not?
Yes, it is an EA decision, but my lord, the point is that within that EA decision, there was consideration of Article 8 at the point of the removal action.
Right.
But it wasn't a freestanding human rights claim.
It was part of the consideration of the EA decision.
Because of Regulation 27.
Yeah, but it was, I mean, if we look, I think the actual decision is the November 2018 decision. My lord, it's 319. Yes, my lord, in the decision, it's a decision under the EA regulations where the focus of Article 8 is on the interim removal under Regulation 33. Your lordship is right.
All right, but forgive me if I'm misunderstanding. But at the moment, I'm not understanding this decision to be a decision rejecting a human rights claim by your client.
No, my lord, that is correct. It hasn't specifically addressed a human rights claim, but I'm trying to, in order to answer your lordship, Lord Justice Lewison's question, is when would this arise? It would arise in a situation where there was consideration of both claims at that time.
Yes, well, that leads on to my original question. What is at the same time?
Well, my lord, for the purposes of paragraph 2 and schedule 2, the operative issue is the removal. And when is the removal happening? And what is the objection to the removal?
So
Here, the objection to the removal was on two bases. The EU law base, which we can't rely on, and Article 8.
right. So EU national arrives in the UK, commits a series of serious offences. The Secretary of State decides that that individual should be deported, takes the national off to immigration detention, and 3 months later sets removal directions. Is that at the same time? Can the potential deportee now bring a new Human Rights Act claim?
Well, there's no time barrier to a human rights claim.
Well, exactly. But my understanding was that your whole point was that these two conditions had to be simultaneously satisfied, and that would only happen if the Human Rights Act claim was decided at the same time as the EEA decision. And I'm trying to explore with you what you mean by at the same time.
My lord, for the purposes of this to bite, it would have to be where there is that nexus, not where it's historical. Because if it's historical, it then deprives the person of the protection which may arise through different circumstances. And that's where precisely the true remedy is Section 94 certification.
Well, I appreciate this is not your argument, but I'd still like to explore with you the question I was putting earlier, because another way of looking at it is that actually subparagraph B is satisfied in this case for the reason you've just actually given yourself, namely, historically, there was a removal of your client from the United Kingdom, which was certified under Regulation 33, but that nevertheless, paragraph 2 doesn't apply, and the reason it doesn't apply is because of your other point, which is that the claim in question, the human rights claim, is not one which arises from the previous EA decision or the consequences of the EA decision. It's one that is based on subsequent facts, allegedly. And if you look at it in that way, it has the advantage, you don't need to worry about these questions of timing. Now, as I say, I'm not expecting you to accept that proposition because it's contrary to part of your argument. But what I would be interested in your assistance with is, if we look at it in that way, what if anything, you could say against it? I mean, as I say, it has the advantage from your client's perspective that it leads to the result that you want, but it's based on only part of your argument, not the whole.
My lord, I don't have any strong objection to that because it achieves the point of making the point that this provision doesn't bite in this situation, and the alternative provision was actually the more accurate provision, Section 94.
All right, but let me rephrase your question. If you're relying on both subparagraphs, it all depends upon what is meant by the removal. And your argument is, well, that must be the removal that's contemplated. Whereas Mr. Howells's argument is, it's the historic removal. And I think I was just wondering if you've got anything further to add to assist us to resolve that dichotomy.
My lord, my simple point in answer to that is that if that were correct, it would undermine the protection that a human rights claim is entitled to. And that was the point that was concerning Mr. Upper Tribunal Judge Perkins, because he was concerned that situations may well change. You may have a legitimate case subsequent to your removal. And if that's right, and you're facing a fresh removal with different facts, it can't be right that this bites to eclipse any right of appeal when there's clearly another remedy.
It doesn't. It transfers the location of the appeal. It doesn't eclipse the right of appeal.
Well, my lord, describing it as transferring the location of the appeal is a big point, because if you're facing a breach of human rights under Article 3 and Article 8, you don't want to be in the location that you're being forced to be in.
But we have to remember, though, don't we, that this is only concerned with EEA states. It's not concerned with dangerous states in the third world.
Well, my lord, that is right, but that doesn't mean that you can't have, there's no absolute prohibition on somebody having an Article 3 claim from an EEA state.
I follow that, but...
Yeah, but I think that it's worth thinking that through in terms of understanding the breadth of the consequences of this, because if that's right, then that is quite a sharp difference in terms of its impact. And that's why there is clearly an easier, more accurate, more versatile remedy that was available. And it wasn't taken. That's the position that the Secretary of State is in, to seek to say, well, and that's how it's happened here. The Secretary of State has taken the view that this is the right interpretation. Our view is obviously that's wrong. There was another version. And that's why the whole argument on policy grounds of the appellant's argument, driving a coach and horses, doesn't bite, because if we say...
That's the force of your point about Article 3. If someone's threatening to kill you in the state in question, then it's very important to you not to be forced to bring your appeal from that state.
Precisely. The location has a big impact. And I would submit also, with respect to Article 8 cases, they may be significant in terms of their impact. And that shouldn't be underestimated. That's the whole point of the protection of allowing in-country right of appeal on Article 8 just as much as Article 3.
Yeah.
So, my lord, those are the points why I say Judge Perkins was actually right in relation to the conclusion he reached, because it had the benefit, his analysis had the benefit of that careful recognition of how the two systems of protection are meant to
Yeah.
My lord, unless I can assist any further on that part of this part of the cross appeal,
Thank you very much.
those are my submissions on
Yeah.
that.
Well, I think we'll hear Mr. Howes in reply and then go on to your appeal.
Well, just three short points, if
Yeah.
I may, in reply. Firstly, may I draw a distinction between Section 94(1) and reliance upon Schedule 2, Paragraph 2? It's being presented by the appellant as though Section 94(1) is the panacea, it's the easy route, it's the obvious route. Why not just do that? I don't accept that. For certification under Section 94(1), the decision maker has to come to the conclusion that the substance of the claim is clearly unfounded and that it is bound to fail. We'll have some discussion about this in the context of relief. That is a high threshold. It will also be borne in mind that Section 94(1) applies across the board to all human rights decisions, whether they relate to EU law or not. Paragraph 2 of Schedule 2 only relates to human rights claims which arise out of EEA decisions or the consequences of EEA decisions. So it's narrower in its focus. It only applies where the claimant has already been deported, and it circumvents the decision maker having to grapple with the merits of the human rights claim and decide whether they are clearly unfounded or not. It is more automatic in its application.
Can I just ask on the point that Mr. Kuba made about 94(1) and 94(b) having the same consequences? Is the effect of certification under 94(1) that you can't bring you have to appeal out of country?
Lord, yes.
But if it's been certified as clearly unfounded and that's been upheld, is then just no right of appeal?
That is now the position.
Yeah.
So that's why my little friend has put in the correct version of the legislation, because it used to be that clearly unfounded claims, the appeal had to be brought from outside the United Kingdom. It's now changed. And we have,
there's no right of appeal.
no right of appeal.
Whether within or without.
Yes.
And that's why 94(b) is only then out, as it were.
Yes.
Yeah. Sorry, I don't think anything turns on it, but I just thank you very much.
Could I just pick up the point you just made about Schedule 2, Paragraph 2 being automatic? I should have asked you this earlier. Isn't that a point against you? Because the very fact that Schedule 2, Paragraph 2 is automatic, doesn't that lead one to the conclusion that it should be narrowly construed? Precisely because it operates like a machine. And anything that operates like a machine, you've got to be sure that it's catching what it's intended to catch.
And to continue the machine analogy, there's a safety valve, and that is an application to revoke the deportation order based on a material change of circumstances.
Thank you.
So my second point probably follows on from that. May I engage with Lord Justice Arnold's issue about a strained interpretation of Paragraph 2, Schedule 2. May I take your Lordship's to Paragraph 2, Schedule 2, page 106 of the Authorities Bundle. And may I pay some close attention to the language used. A, the claim to which the appeal relates arises from an EEA decision or the consequences of an EEA decision, and then B, the removal of that person from the United Kingdom has been certified. The difference in language used is important between an EEA decision and the removal. So the provision envisages a human rights claim arising from an EEA decision or the consequences of an EEA decision, which do not have to be the removal. That is the plain reading of those words. An EEA decision is wider than the removal. And so in my submission, it's not the Secretary of State who's putting a strained interpretation on these words, but rather it's the appellant who's putting a strained interpretation on them, because the words do not bear the suggestion that they have to take place at the same time.
Do you say that the claim in the present case arises from an EDA decision, or do you say that it arises from the consequences?
The consequences.
Right.
In my opening motions, I identified two consequences of the removal decision. You cannot be admitted to the United Kingdom, and you are subject to administrative removal, and you have to make an application to revoke the deportation from out of the country. Those are two consequences written into the legislation of the removal decision.
And can you just help me, how does the claim that the appellant's human rights are being infringed arise from the consequences of the decision?
So the decision that's giving rise to the human rights claim is the Secretary of State's refusal to entertain an application to revoke the deportation order from in the United Kingdom. And that's going to have the consequence that the appellant is removed administratively from the United Kingdom. Both of those are consequences that are plain on the face of the regulations themselves.
Well, it's true that there's a but-for causation, but, you know, as we all know, the problem with but-for causation is it proves everything. But his claim is based upon things that he says have arisen subsequent to the deportation decision. So why do you say that it's based on the consequences of the EA decision, or do you say but-for causation is enough?
It arises from the consequences of an EEA decision, because if the claimant wants to rely upon a change of circumstances, then he has to make that application from outside the United Kingdom. So the claimant, the appellant can't circumvent this provision just by saying, oh, I'm relying on a set of facts that have developed in the 3 months since I was deported. It has nothing to do with the consequences of the deportation, because that's a fallacy. The reason why he's in an unhappy situation in Portugal is because he was deported, and he is not, doesn't have a right to be admitted to the United Kingdom. The two cannot be separated out in the way that the appellant says they can.
Yeah.
My third point is just a short point, and this is about the Article 3 claim. I repeat the submission I made in opening, that the Secretary of State does have a discretion, if an Article 3 claim is made, to treat it as an application to revoke a deportation order and waive the requirement for it to be made outside the United Kingdom. In appropriate cases, there is a discretion for that to be done. But moreover, it is important always to bear in mind that when the claimant appellant was deported, he could have raised a human rights claim, but did not. He signed a disclaimer. He could have raised a human rights claim, and anybody in those circumstances with a concern about the conditions in the state to which they are being returned can make the Article 3 claim at the point of deportation. It's a relevant consideration at the point of deportation.
What if the threat to kill him is only made when he gets back home?
Then that's where the discretion comes into play.
Yeah.
And that's a discretion referred to by Lord Justice Sales in Amatemo. My lords, those are my points of reply.
Thank you very much. Right, Mr. Kubar, let's move on to your appeal.
My lord, if I can just say briefly, I've set out detailed submissions in my skeleton
Yes.
on the issues that the appellants raised in the cross appeal. I just refer back to those for the purposes. In relation to my appeal focuses on what happened after the long journey of the discussion between the relationship of the sections, and paragraph 51 of the judge below's decision. Paragraph 51 is at page 157 of the bundle. And my lord, if you see paragraph 51 there, you'll see that this was the reasoning given by the judge, and he was looking at this in terms of a new decision being made, and that new decision being made under section 94, and that decision being one that could be made to block any right of appeal.
What does he mean by any new decision?
Well, he seems to be relying on section 31(2)(a), but he's looking at some future prospective decision that the Secretary of State would make on the basis that relief is granted, but there would then have to be another decision.
Why? This goes back to a question I asked you right at the beginning. I simply don't understand. If the Secretary of State is wrong, as the Upper Tribunal said she was, in saying you don't have an in-country right of appeal, what fresh decision needs to be made? You simply exercise the right of appeal that the court has told you you've got.
Yeah, subject to the point about the implications of no quashing order. But the point here,
What are the what are the implications of no quashing order?
Well,
If the Upper Tribunal has ruled as a matter of law,
Yes.
or if this court rules as a matter of law, your client has an in-country right of appeal.
Yes.
Why is that not at very least an issue estoppel between you and the Secretary of State? How can the FTT say, well, the Court of Appeal said you've got an in-country right of appeal, but we ignore that because you didn't get a quashing order?
Well,
Can't be right.
my lord, that may be a point of debate if that had happened or were to happen. But I think the point being made here is there's no prohibition on the Secretary of State making a fresh decision under section 94 to try and defeat an in-country right of appeal. I mean, that would obviously raise issues in itself in terms of its timing and its consequences. But what I think the judge is saying is that here, the impact of what I've said in relation to you succeeding on your legal argument is effectively academic, because the Secretary of State can make another decision, which is a section 94 decision, and that would...
But your point is a very simple one. That's a decision that's not yet been made.
Exactly.
That's a future decision. Secretary of State has the power to do that, but it's for her to do that if and when she chooses.
Exactly. And it's not for the court to start immersing itself into the role of the decision maker.
Well, it's not for the court to take a decision the Secretary of State hasn't yet purported to take.
Precisely. Yeah. I mean, it's just going too far in terms of what section 31(2)(a) permits. I mean, that's very simply the point as to what's gone wrong here. And I mean, it's not helped by the fact of the very lengthy delay between the hearing and the judgment. You will have seen from the papers that it's over 10 months after the hearing that this decision was finally released.
It's also not easy to see what the conduct complained of, how you fit. I mean, the conduct complained of is...
It's the hard-edged legal point that it's a binary answer. You either have got a right of appeal or you haven't, as we've discussed. And if I'm right, you have got a right of appeal. That's the conduct complained of. How can you usurp that by making?
But what conduct?
Well,
The Secretary of State got the law wrong. That's the conduct complained of.
that is the conduct that was complained of here. It's
So
a
if the
statutory
In
interpretation.
other words, if the Secretary of State said yes, you've got a in-country right of appeal,
We wouldn't be complaining.
then there's nothing for Section 31A to bite on.
But I mean, if the decision had been positive, this case wouldn't have arisen. But because it has arisen, the conduct complained of, I'm trying to fit it into the scheme of Section 31(2)A, is it's one of statutory construction on a particular provision. And
But why are you trying to fit it into Section 32(1)A? Because surely your point is it doesn't fit.
yeah, well, that's what I mean. It doesn't fit in terms of trying to understand it. In terms of the analysis required, it doesn't fit.
Can I just ask you, assuming just for those purposes that you're arguing, judicial review is always a discretionary remedy. In fact, as my lord pointed out at the beginning, perhaps you should have just gone straight to the tribunal and said we have an internal right of appeal, and perhaps the Secretary of State, albeit diverted by your other grounds, should have pointed that out to the decision maker. But you didn't go there, and you didn't do that. But just in terms of a discretionary remedy, if the Upper Tribunal decided this is a hopeless Human Rights Act claim, you signed away your rights, you went to Portugal, you waited 3 months and you came back illegally, no one is going to give any time of day to this. Why, as a matter of discretion, should you be granted any relief?
My lord, I can see that as a matter of discretion and materiality, a court could reach that decision. But in order to do that, it would have to make a very carefully reasoned decision. And my point is, that's where it feeds into my other point in my submissions on this, is that there is no proper engagement with the Section 94 context to this case. And in particular, if you look at the wording of the judge's decision under paragraph 51, he focuses on a lot of things that are not applicable to this claimant's case. His case is more about private life, having been here for over 20 years. It's not really a family life case. He can't really meet that kind of case. And that's why it's deficient in terms of that lack of anxious scrutiny. So in principle, your lordship is right, is that if you're looking at a discretionary remedy, materiality, a judge could look at that and say, well, actually, I've looked at this fully, and these are my reasons why this isn't going anywhere. That's possible, but that's not what
You're
happened.
going to say there's no respondent's notice from the Secretary of State saying that even if Section 32(1)A is not available, relief should be refused on discretionary grounds.
Yep, no, that's right. But the point here is he hasn't immersed himself with that question to the level required in terms of any rejection on materiality grounds vis-a-vis discretion. My lord, I've set out in more detail in
Yes.
the skeleton the discrete elements, but I think I've perhaps crunched through the key elements of why the reliance on Section 31(2)A was flawed here to deprive the claimant of his remedy. Unless I can assist you.
All right, thank you very much. Yes, Mr. Howells.
Lords, in light of the questions that have been asked, may I begin my reply by looking at some of the case law, and in particular the judgment of one judgment of Lord Justice Sales again, where he makes the point that simplex test, which is the materiality test, has been modified by Section 31(2)A. So we can't proceed on the basis that we can't ignore Section 31(2)A and carry on applying the simplex test because Parliament has legislated and it's reduced the threshold. The simplex test was the result would inevitably be the same. Section 31(2)A test is highly likely would not be substantially different. It doesn't have to be the same. So it's still a high threshold, but a lower threshold. And that point is made in the case law. And if I may just adopt the point, the point made in the question asked by His Lordship Lord Justice Dingemans about, well, why refuse relief? Well, the reason you refuse relief is to dismiss the claim. judicial review is about practical outcomes. And actually, if the claim was academic all along, then it's entirely appropriate for the Upper Tribunal to refuse relief and dismiss the claim. It has to be borne in mind that paragraphs 2 and 3 are relief is refused and the claim is dismissed because the claim should never have been brought, because it will make not one iota of difference to this appellant whether he doesn't have a right of appeal because of the application of paragraph 2 schedule 2, or because it's inevitable or highly likely, I'm doing it myself, that the Secretary of State would certify his human rights claim as clearly unfounded under section 94(1). And it must also be borne out the practical consequences for the Secretary of State. If the claim were allowed and section 31(2)(a) were not applied, then the result would be that there would be an in-country appeal right, unless the Secretary of State withdrew the decision and made a new decision certifying it under section 94(1). Well, the point...
Why section 94(1)? What's wrong with section
Clearly unfounded.
94(b)?
No, section 94(1). Section 94(b), the operational guidance at the time was not to use it in EEA decisions because Regulation 33 was the mirror provision. So that's why I focus on section 94(1) and clearly unfounded. And that point was made clear at the Upper Tribunal. I know that my pleading refers to section 94(b), but by the time it got to hearing, I relied on 94(1).
I'm confused because you talked about the order of the Upper Tribunal dismissing the claim. I thought what they did was dismiss the claim for judicial review, not the underlying human rights claim.
Well, yes, dismiss the claim for judicial review.
So then that's what's so puzzling about this aspect of the case, as my lords pointed out, because the judicial review was all about from where the appeal had to be brought, not about its substance.
I agree, my lord, and that is why the Secretary of State pleaded section 31(2)(a), because even if the appellant were right, the Secretary of State would wish to certify under section 94(1) so the result was the same.
You can do that. That's why we keep going round in circles, because nothing's stopping the Secretary of State doing that anyway. And that would be a fresh decision. And of course, you know, I understand your point that theoretically, at least, that it might be subject to judicial review. But you know, the Secretary of State can always do that.
For reasons already canvassed, the Secretary of State relied on paragraph 2 schedule 2 as the appropriate mechanism in this case. A judicial review.
And if the Secretary of State was right about that on the law, end of case. But for this purpose, we have to assume the Secretary of State was wrong. And there was, in law, an in-country right of appeal. But in addition, the Secretary of State had then, and still has, the power to certify under section 94(1).
Well, yes, and that is why the Upper Tribunal was invited not to grant any remedy, because it was highly likely that the in-country appeal right would be taken away. So the outcome for the appellant would be practically the same. He wouldn't have an in-country appeal right. Which is another way of saying this whole claim was academic. It shouldn't have been brought, and it shouldn't be allowed with the Secretary of State paying the costs. All those practical consequences of a claim being allowed, declaration made, quashing order, costs order. And that is why section 31(2)(a) is there. Is to stop claims being brought with the consequent resources that it uses, but it achieves no practical outcome.
So just going to 31(2)(a), what is your interpretation of the phrase "if the conduct complained of had not occurred"? The conduct complained of, it seems, is the Secretary of State's, on this assumption, erroneous statement that there was no in-country right of appeal.
Yes.
So if that had not occurred, then there would be an in-country right of appeal, wouldn't there?
Well, my lord, no. So that's the but-for test. So but for the erroneous application of paragraph 2, schedule 2, what would have happened in this case? in my submission, it is highly likely that had the Secretary of State appreciated the misinterpretation of the law, that they would have certified the in-country right of appeal under section 94(1 with the same result under section 92 subsection 3 that the appeal had to be brought from outside the United Kingdom. The result is the same.
But that's what that is asking the court to do, is to step into the shoes of the decision maker, isn't it? Because you're asking the court to suppose that a power which has always been available to the Secretary of State will be exercised and will be exercised in a certain way, and for the court to preempt all of that and say, we're going to decide it ourselves. Is that constitutionally appropriate?
Well, my lord, the Court of Appeal have been troubled by this on a number of occasions, and can I take the court to at least two of those? Because the distinction, the dividing line between stepping into the shoes of the decision maker, but actually not shirking the responsibility under section 31(2)(a) to make the decision as to what is highly likely in any event, it is a fine one, and the Court of Appeal have given some guidance on this. So may I begin with the authority of Goring. Goring on Thames Parish Council and South Oxfordshire District Council 2018 Court of Appeal 860. It's in the authorities bundle at 255. Begins actually at 253.
Yeah.
But could I draw the court's attention to the head note on 255, just so to describe the circumstances of the case. So by a claim form, the claimant, the council, the parish council, sought judicial review of a decision of the defendant local planning authority to grant planning permission to an interested party for a scheme for the development of turbines to generate hydropower at a local weir. Mr. Justice Cranston allowed the claim.
Sorry, where are you reading from?
So in the middle of page 255. Authorities bundle on
Yeah,
page 255.
thank you. Yeah.
Under the heading application. So just a summary of the case. Mr. Justice Cranston allowed the claim to the extent of granting a declaration that the District Council's decision failed to comply with the duties in section 72 of the Planning List of Buildings and Conservation Areas Act 1990. I just pause to interject that that is a duty to provide, to attach significant weight to a particular consideration. And the reason why I'm setting out these facts is because they feed into this distinction between decision maker and what's highly likely. Then could I ask the court to look at paragraph 23. This is how Mr. Justice Cranston decided the substantive ground. So the Court of Appeal set out, Mr. Justice Cranston, at paragraph 68, if the council did fall down in fulfilling its section 72 duty, as I conclude it did, there is the separate question of whether it appears to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. And then paragraph 69 of the quotation, in my view, it is highly likely that the outcome would not have been substantially different if the council had applied the correct test. If there was any harm to heritage assets, the response of both conservation officers from the council and West Berkshire Council was that it was at most minor harm. That approach then became part of the officer's report. More importantly, the factors weighing in favour of the grant of planning permission were weighty. The opportunity of generating renewable energy from existing water source. In my view, there is simply no prospect that this issue would make any difference to the overall planning balance if the decision had been taken in accordance with section.
That's exactly what one would expect. So a decision has been taken by a decision maker. They applied slightly the wrong test, and the court says, well, if they'd applied the right test, they would have still come to the same decision. But how does that apply in circumstances where what's postulated is that the decision maker would not have made the same decision, but would have exercised a completely different power available on different grounds?
My lord, so the criticism that was made in the Court of Appeal of Mr. Justice Cranston's judgment is that he was engaging with the merits and entering the forbidden territory and making a merits-based decision.
And the answer
What-
given was he was doing what the statute required.
What is such required? What the Secretary of State invited the Upper Tribunal to do in this case was to decide whether it was highly likely that any decision maker would certify this claim as clearly unfounded. Now, the appellant criticises that for entering into a decision about the merits and whether the underlying claim was wholly unfounded or not. The point that I make based on this case is that engaging with the merits is an inevitable part of addressing the statutory question, as long as the court is addressing its mind as to whether it is highly likely that a decision maker, but for the misinterpretation of paragraph 2, schedule 2, would have certified it as clearly unfounded, and so would not have given the appellant an in-country right of appeal. It's the focus of the test is the outcome. Whether the outcome is highly likely not to be substantially different. And then, my lords, could I take you to paragraphs 39 to 42 on page 265? Paragraph 39, just to identify what the arguments were very briefly. Paragraph 39, the first argument was that Mr. Justice, the section 31(2)(a) had no application when a claimant succeeds in establishing a substantive error of law as opposed to a minor procedural irregularity. And again, there'll be some similarity to the appellant's argument in this case, that you made an error of law about the right of appeal. You can't use section 31(2)(a), you made an error of law. Paragraph 41, the second argument was that in performing the section 31(2)(a) duty, Justice Cranston ventured into the planning merits. And then the third argument, paragraph 42, in deciding not to quash the planning permission, Mr. Justice Cranston had failed to recognise the strength of the statutory presumption under section 72. And again, that bears a certain similarity because in this case, the appellant's arguing that the Upper Tribunal judge didn't understand the high threshold for the clearly unfounded test in section 94(1). So there's certain similarities in the way that the decision was sought to be undermined. And then the conclusions out of paragraphs 54 to 55. As to Mr. Streeton's submission that Lady Justice Rafferty did not grapple with the argument that Mr. Justice Cranston, performing the duty in section 31(2)(a), had descended into the merits, our conclusion is essentially the same as on the first argument for essentially the same reasons. The mistake in Mr. Streeton's submission here is that, in the context of a challenge to a planning decision, they fail to recognise the nature of the court's duty under section 31(2)(a). It is axiomatic that, when performing that duty, or equally when exercising its discretion as to relief, the court must not cast itself in the role of the planning decision maker. If, however, the court is to consider whether a particular outcome was highly likely not to have been substantially different if the conduct complained of had not occurred, it must necessarily undertake its own objective assessment of the decision-making process and what its result would have been if the decision-maker had not erred in law. And I place great weight on that passage in this exchange because the Upper Tribunal was entitled to carry out an objective assessment of the decision-making process and ask itself, had reliance not been placed on paragraph schedule 2, would the claimant or the appellant have had an in-country right of appeal? The answer to that is highly likely not.
Can I just test that? Because I mean, I understand all the points you make about, well, this is a hopeless Human Rights Act claim. He went to Portugal for 3 months, then came back, and it was never going to fly. But just dealing with the conduct complained of, that is the error that the Secretary of State made. But would the decision have been the same? Because here, there has to be a new decision under section 94. There never was a decision under 94. The Secretary of State just assumed that paragraph 1 and 2 of schedule 2 did it for her. And in those circumstances, do we have the right to make a decision that has not been made. It's different. I ignore the fact we're entering into the merits. I understand all those points, but do we have the right under section 31(2)(a) to make a decision under a provision that the Secretary of State has not used in this decision-making process?
My Lord, 2 points if I may. Firstly, the Secretary of State does not need to show that the decision would have been the same. What the Secretary of State needs to show is that the outcome
All right, very likely.
would not have been substantially different.
Ignore my.
So, but it's important because in my submission, the outcome is whether or not the appellant would have had an in-country right of appeal or not. That's what this is all about. In my submission, it's highly likely that in any event, he would not have had an in-country right of appeal by hook, by crook. Secondly, in terms of making the decision, if you take the example of Mr. Justice Cranston, significant weight had not been attached to Section 72 in the way it should have done. It was necessarily part of the intellectual exercise that he had to remake the decision, attaching the weight that should have been attached. So whenever the court is addressing the question of whether an outcome is highly likely to have been the same, it is engaging in a certain amount of remaking the decision on a prospective basis, making an objective assessment of what the decision-making process would have been. I want to take your lordships to a second case. And before I do, just to finish off this point, the second case is about a failure by an officer to make any reference to the public sector equality duty in a report. So Section 149 duty had not been complied with.
Can I just ask you, Mr. Howell, how much longer are you going to be?
Probably 15 minutes, my lord.
15 minutes. And you'll want to reply, Mr. Kubal?
My lord, briefly, yes.
Well, in that case, I think we'll come back at 2 o'clock.
Court rise is able.